So today, in continuation, with where we left in the last class, we were discussing about the relation between equity and common law. Mm, we had already discussed the basics, and then we left at what Hohfeld had to say about the relation between equity and common law. Just give me a second. I will connect the Bluetooth, and I think the audio will be clearer then. So I hope I'm audible. I'm clearer now. Okay. So yes. So Hofeld's position, unlike Maitland's position, has been that when there is a conflict between equity and common law, and then equity in fact prevails because um, these rights have a kind of higher sanctity, just like a constitution has. So this is the position that was held by Hohfeld. So before he goes into showing you different kinds of rights, different instances of rights where there is conflict between equity and common law. He gives you certain introductory he provides some introductory remarks on certain fundamental characteristics of equity. So in the last class we were discussing about different ideas, guiding ideas and maxims which are used in equity. So the most important ideas are that equity is done in the name of conscience, good faith, reason, and of course equity. Apart from that, we have 11 different maxims that we are going to study later on in much in a greater detail, and those are: equity will not suffer a right to be without a remedy. So basically, if there is a right, there will be a remedy. If you remember the different kinds of jurisdiction, especially the concurrent jurisdiction that we discussed earlier, and this maxim essentially applies there. Then the next maxim is equity regards that as done which ought to be done. Then you have equity looks to the intent rather than to the form. Equity imputes an intent to fulfill an obligation. Equality is equity. He who seeks equity must do equity. He who comes into equity must come with clean hands. Where there are equal equities, the first in time shall prevail. And where equities are equal, the legal title will prevail. Equity aids the vigilant and not those who slumber on their rights. Equity follows the law. So these are some of the very important maxims that we are going to study in greater details. I'm not going to explain them here because we'll be unnecessarily consuming our time here. So yes, so these are the 11 maxims which are applied by the which were applied by the court of equity earlier. Okay, as of now, because most of these remedies have become very ossified, okay, legalized. So these maxims do not have as much flexibility as they had earlier. Okay, so they merely act as guideposts. Okay, and must not be taken literally, as Hohfeld says. So these are some of the very important maxims that you will come across when we study equity, that we are going to discuss in greater detail later on. So he then identifies certain characteristic features of equitable remedies and procedure. Okay, so what are those? If you remember, we had already discussed this in the earlier class, that the remedies which are provided by the court of equity are preventive in nature, whereas legal remedies are reparative in nature. So what do I mean by that? It's simply that so if you are seeking remedy from the court of law, there has to be a violation of the right already. Okay, so only if there is a violation of the right, legal right that you have, can you go before the common law court and then seek remedy. Okay, but you can approach the court of equity even before the violation of that right has happened. So you are under the fear, okay, so that there's a very high likelihood there is a threatened violation of a right, okay. So mere compensation, reparation is not sufficient. You do not want the right to be violated. So for example, if you have a tree in your garden that you do not want to be cut, but someone may come and cut that, okay. So for you to be provided compensation later on, after the tree has been cut, is of much less importance than the tree not getting cut. So in such case, you seek some preventive remedy that will be available only under equity. So historically, this is how such remedies were provided. So, and those remedies are available to you under laws of equity in England. So yes, another distinction is that the distinction between specific reparation and non-specific reparation. So if you go before the common law, the reparation that is provided to you is in the form of non-specific reparation. So it's in the form of damages. So before the right has been violated, you cannot possibly know what specific reparation will be provided to you. Whereas in case of court of equity, you can reasonably foresee, in the general sense of the term, what the reparation will be. Because you know the quantum of the reparation, okay, that is because of the nature of the rights, it is knowable for you beforehand, okay. So it gives you certain examples. So at law, if right has been violated, the remedy is non-specific reparation, that is damages, okay. But there are certain exceptions to that. It's not always the case that in law the remedy is always non-specific. Sometimes it could also be a specific. So some of the examples are recovery of possession of realty. Now when it comes to for example, you want to eject the tenant, okay, so you know what the remedy is. It's very specific, so there is no question of non-specificity. Then you have recovery of possession of specific property, so as known as replevin. Because it is specific personal property, you know the exact value of the property. So again, the reparation is quite specific. And then you have recovery of damages for breach of an obligation to pay money. Okay, so you know that when there is an obligation, to pay money, what's the specific, amount, that is to be paid back to you. So in all these cases, even though you have legal remedy, the remedy is quite, specific. The reparation is quite specific in nature. However, apart from that, others, for example, if there is a breach of contract, the damages, if that is the remedy, will be quite, non-specific. Okay, so same goes for many other kinds of legal remedies. And then you have equitable remedies. Okay, so as we discussed earlier, equitable remedies are quite specific in nature. Okay. As I said, okay, so preventing someone from cutting a tree, okay, or compelling someone to make a particular transfer. So those are the sort of remedies that quite often you seek in the court of equity. So yeah, that's that. So I hope you understood the distinction here. Then he finds that equitable remedial proceedings and decrees, when contrasted with legal remedial proceedings and judgments in relation to powers of courts and parties in securing their performance and satisfaction. So when it comes to securing performance and satisfaction, the court of equity and the court of common law deal with the same in a very different way. Okay. So he says that at law, the judgment in personam creates obligation, okay, performance of which, however, apart from what are now comparatively rare cases of arrest or execution against a person, is not coerced by duress of impending or actual imprisonment. So because civil suits in a common law court or civil in nature. So of course there is no question of coercion through arrest arise. Okay, arrest or other duress arise. Okay, however, the same cannot be said of common law courts. And if you know. If you were to apply, if you were to approach the court of equity, then because it has the power to compel or coerce someone to make certain transfers, okay, certain change in legal relation through application of law. It doesn't directly do that. It compels that person into doing that. So for that, they quite often need to exercise such power. Okay, so how the right is realized? Okay, on that question, you have different approaches. So anyway, I hope this is so far clear. So you will see in India, the civil court also has the power to arrest someone. So these are some of the powers which had historically emerged from the court of equity, because it's the peculiar nature of the remedy which is provided to you. So because of that, sometimes the court also needs to exercise certain powers which are of criminal nature, although that doesn't amount to one committing crime, but the coercion which is applied is kind of things that you see in criminal matters. So as he says that law, the judgment in personam, creates a new obligation. Okay, a new obligation is created, performance of which, however, apart from what are new, comparatively rare cases of arrest or execution against the person, is not coerced by duress of impending or actual imprisonment. Okay, so these are the things that you do not see in common law court. Okay, so in ordinary judgment for damages, satisfaction is had from proceeds realized from sale of defendant's property. So what is to be paid could be realized by selling of defendant's property. And similarly, in judgment for recovery of possession, physical corpus of reality or personality. So sheriff, acting by authority of writ of possession. So if it is recovery of specific property, so through coercion, using state machinery, the possession is given to someone else. So these are the only things that happen in common law. Okay, but as I told you, in court of equity, because it's not a matter of creation of a new right by application of law, but compelling someone to do something. Okay, because of that specific nature of the right under the equity, that quite often performance of which by the obligee is usually coerced by duress, okay, of impending or actual imprisonment for contempt of court in case of disobedience. So for example, let's say that, okay, in the case of equity of redemption, so once the debt has been paid, okay, the other person is not transferring the property back. Okay, in such case, the court of equity might use its power of coercion using impending arrest or actual arrest. Okay, and for contempt of court, because the order comes from the court of equity, so you follow it. Okay, otherwise you will be imprisoned for contempt of court, and through that fear they can compel you to perform the specific obligation. Okay, so what Hohfeld says that this is usually a sufficient sanction to secure performance of the degree of the degree obligation. So I hope this is clear. So when the common law application of common law happens, the application of the law itself results in change in the legal relation, as we discussed earlier. But the same does not happen directly in case of equity. It happens indirectly. So court of equity compels a specific person to bring about those changed legal relation. And how does it ensure doing that? It ensures that by threat of imprisonment for not following that order, under contempt of court. So this is the essential distinction that you see between how essentially how the rights are actually realized. Basically, the different kinds of powers that the court exercises, common law court on the one hand and the equity on the other, in realization of someone's rights. Okay, either under common law and equity. That is the performance and satisfaction on the part of the defendant here. So yes, next Hohfeld says that equitable remedial proceedings and decrees when contrasted with legal remedial proceedings and judgments in relation to parties, conditions, administrative and advice. Okay, so what are those? It says that equity can deal with controversy to which there are more than two parties. So this is another specific characteristic of right of equitable nature. So take for example the case of suretyship. Okay, so how many parties do you see there? You have A, who's the creditor, and then B, who's the principal obligor or the debitor here. Okay, and then you have a third party who's the surety. So you have three parties. Okay, so the third party is not directly concerned in this relationship. If the obligor fails, then surety is so if relations are of this triangular in nature, you have three different parties. Okay, then those relationships are of the nature then you can know that okay, these are the things that come under the equity jurisdiction. Okay, but that however does not mean that okay, there cannot be more than two persons in a legal dispute. So there could be A, that might under A you might have multiple persons, and B, under which you have multiple persons. Okay, so however the entities are A and B. Okay, so those are again different kinds of relations. Those could come under common law, but under equity you usually have three different parties involved. So I hope this is clear. Okay, so that's why he says that equity can deal with controversy to which there are more than two parties. Okay, whereas law cannot. Okay, when he says law, usually is referring to common law, cannot. Then he says that equity may, when necessary or just, give conditional decrees. Okay, the same is not possible under the law. Now, whatever decrees issued by the common law under common law has to be absolute, because it's absolute determination of a matter of right. Whereas in equity, it could be conditional. Okay, so examples given. I think more than this example, it's simply this, that why could it be conditional? So I mentioned a few maxims earlier. Okay, so he who seeks equity must be willing to do equity. He who seeks equity must come to equity with clean hands. What are those maxims? You see, there are certain conditions out there. Okay, so whereas when you approach the common law, the rights that you seek there are not conditional. Those are already, if you apply the law, you will have a particular right, and then you will have such remedies. Whereas in case of equity, that's not the case, and hence it is conditional. Whereas in case of law, it's unconditional. Okay, it could go in favor of either of the party. So yes, he has given an example: an equity court's refusal of a temporary injunction in a patent infringement case on condition that the defendant keep an account of all sales. So you see, certain condition has been imposed here, that the defendant keep an account of all sales to be made pending final hearing. So such kind of conditions can only be imposed by the court of equity. Then another important distinguishing factor that he identifies is that court of equity exercise administrative functions. Okay, so what administrative functions are not something that you see in the ordinary law courts. So under common law there will be no such administration. So what will be the examples of administrative functions? So in case of will, okay, when a person dies, okay, how the will is to be disposed, okay, that is dealt with by the probate court, isn't it? Now, the function of probate, okay, that specific function of administering the property of someone who's died, okay, leaving behind a will, okay, that is not what we understand as adjudicative function. Okay, that's not an adjudicative function. That's of administration. Okay, administrative nature. So that's the function that you find in equity. Okay, that you find under the equity, and hence court of equity exercises the said function. The same goes for receivership of proceedings. Okay, because the same has to be again distributed. Okay, so administered. So any function of that sort, okay, that involves administration of something, some property, then that comes on, that's such function which are of administrative nature comes within the jurisdiction of equity court, or it is of equity. It is dealt with by the court under its equity jurisdiction. Then another important function is that equity suits may be advisory as well as contentious. So what does that mean? It could advise you to take one course or the other. Okay, the other one is where it is purely contentious between two different parties. Okay, whereas legal proceedings are always contentious. There is no question of advisory function in equity suits. So example given is a trustee's bill for advice from court of equity. So yes, anything, I mean, as to how to, for example, how to deal with a property. Okay, how to deal with a property in the absence of specific instruction when it comes to trust property. Such powers are not exercised by a trustee in the absence of specific instructions on his own. He has to seek advice from the court as to how to deal with the property. Okay, so what kind of function is it? It does not ultimately determine what the the question of right on any matter. Okay, these are advisory in nature. So if things are of that nature, then it is the function of court of equity, or the court under its equity jurisdiction. Then there are certain limits, okay, general limitations on what kind of remedies can be provided to you. Okay, so one very specific interesting power that the court of equity has in providing remedies is that it can provide remedies in an indirect way in relation to a matter, okay, in relation to a property which is not situated within its physical jurisdiction. Okay, so for example, a property is situated somewhere in the United States, but the court is in England and the parties are there, okay, in England. The property is situated elsewhere in the United States. That court does not have any jurisdiction over the property because it's not within the physical jurisdiction, territorial jurisdiction of the court. Okay, so one of the specific power that the court of equity has is to be able to influence property situated elsewhere. Okay, so it does not deal with that property directly because it doesn't have the jurisdiction, but then, as you know, it can compel one of the parties who's within the jurisdiction of the court to do or not do something. So for example, to transfer the property or to take care of the property in a certain way. So even though the property is not within its territorial physical jurisdiction, but since one of the party is, so using its power to compel one of the parties to do or not do something, okay, it can then affect the property situated somewhere else. However, this power is not absolute. There are certain limitations on this specific power. Okay, so what are those? So Hohfeld identifies that limitations dependent on nature of equity procedure and remedies. Okay, so one is, when equity court gets personal jurisdiction over defendant, it can grant a remedy by decreeing that the defendant do or refrain from doing a given act. Example, making of the conveyance, though the rest subject matter to controversies outside of the jurisdiction. So this is what I just explained to you. Okay, that it can compel someone to do something or refrain from doing something with respect to a res. Okay, the property, as you know, are in the rights with respect to that are in rem, whereas personal obligations are of the nature of in personam. Okay, so here the court exercises its jurisdiction and personally compels someone to do or not to do something with regard to it. So it does not directly affect the real property. here. However, this is a power that the court of equity or court under its equity jurisdiction can exercise indirectly. Okay. So then he discusses different limitations on this power. So even though the res subject to controversies within the jurisdiction, okay, and even though the court have personal jurisdiction over the defendant, an equity court is not empowered to grant a remedy directly affecting the title to the res. So you cannot exercise your power. If it were court of equity, it cannot exercise its power to directly affect the res. It can indirectly compel someone to do or not to do something, but it doesn't have the power to directly affect the property. So that's the indirect application of the power here. Okay. So then number 3, he says that when the res is outside of the jurisdiction, a fortiori, a court is powerless to grant any remedy directly affecting the title to res. This is clear in the absence of statute, and even a statute could not give such power. So basically, more or less the same thing here. Okay, is that court cannot directly affect the property. It can do that indirectly, but cannot do so directly. When I say indirectly, it can compel someone who's within its jurisdiction to personally not do or refrain from doing something. Okay, so it does not have direct jurisdiction on the property. So on the property, on the res. Okay, so that's the limitation on equity jurisdiction. Then in point number B, he says that limitations do not depend on nature of equity procedure and remedies. Okay, so what is that? In general, equity will exercise jurisdiction only where the law fails to give you adequate remedy. Okay, so this is more or less the two kind of jurisdiction that we discussed earlier. Okay, so equity will exercise jurisdiction only where the law has failed. So in one case, if you remember, the concurrent jurisdiction where equity provides you remedies when the remedy under the law is insufficient. Okay, so case of trust, and then equity of redemption. And then then you have certain remedies. Those remedies are inadequate remedy. Okay, so what are those? So for example, injunction against defendant threatening to cut ornamental trees. Okay, so preventive in nature. It stops someone from doing or not doing something. Okay, essentially something. Some remedy which you might have under, for example, damages as a remedy which might be available to you under the common law is not sufficient. So in those cases, the equity can step in and help you. Okay. Then he finds that equity will decline to exercise jurisdiction because of special impolicy or inexpediency. So there are certain cases in which even though the court might appear to have jurisdiction, but it may decline to exercise the said jurisdiction because of special impolicy or inexpediency. What would that be? So an example that is given is it will not compel the defendant, to render personal services. That's of different natures, not proprietary in nature, but personal service. Okay, why would that be? So it says that impolicy and inexpediency. So expecting someone to be compelled to do some personal services seems to be unethical, isn't it? So in those matters, court of equity will not compel someone. So he says that example 9 that he provides is equity will refuse affirmative decree of specific performance of defendant's contract to render personal services, even though the latter is unique. So in such case, one can expect damages rather than specific performance, because specific performance would require someone to be compelled to do something of personal, of the nature of personal services. So that's not acceptable, isn't it? So hence, because of this special impolicy and or inexpediency, equity will not exercise this jurisdiction. Okay. Then he says that equity, under equity there could be a decline to exercise jurisdiction in relation to foreign res or other matter. Okay, in what? So usually in some matters they do exercise jurisdiction. In certain others, the court will not exercise this jurisdiction. So what would those be? So partisan suit, or winding up a foreign trust, or suit to compel defendant to do affirmative act in a foreign jurisdiction. So in all those matters, the court could. So these are examples. Okay, these are not, these could change. Okay, statute can bring about changes, but generally this is what he had observed, that these matters, if the res is situated in a foreign country, then the court does not, equity court does not interfere. And then finally, he says that equity will not give relief against criminal acts as such. So as I told you, that equity deals specifically with matters related to matters of civil nature. Okay, so if the matter is a criminal matter, there is no question of rights. So there is no question of it's something that is illegal, isn't it? Whereas in case of matters of civil nature, there is no illegality of rights there. Okay, whereas in crime it is clearly a case of illegality, so there is no exercise of this jurisdiction in such matters. Okay, so it will not prevent a crime by issuing injunction or something like that, or provide reparation. But if it is a right which is recognized under the common law, then of course equity, but then that steps in. But then that is a civil matter, not a criminal matter. So I try and understand this. So crime, when someone tries to commit a crime, we know that this is something illegal. Okay, this is illegal. There is no right that is considered a valid right under the law. Okay, so the very inception of the thing is illegal. So there is no question of relief under the equity. Okay, so it will not provide such a remedy through either prevention or reparation. You have remedies under the common law. That's sufficient enough though. So equity will not concern itself with acts merely because they are crimes. Okay, this is however not true in very early days of equity. So historically, there must have been cases where even when the matter, in some criminal matters, some kind of, preventive, protection must have been provided, but of which I am not aware. However, it says that if a threatened criminal act, apart from the fact that it is criminal, would constitute violation of property right warranting equitable relief, equity will give relief. So see, it is not the criminal act against which the protection is provided by the court of equity, but that along with the criminal nature of the act, okay, if it also leads to violation of certain property rights, okay, but because there is already a property right, okay, which is to be violated, okay, so in such case we are also assuming that maybe legally the other person could have done something, but not under equity. Because of that, specific remedy is provided under the equity, but it has to have that property right nature. Okay, so yes, so these are some of the essential nature and distinction that he draws between common law and equity. So then he goes on to finding out what happens when there is a conflict between common law and equity. I will not take all the examples. I will take just a few examples, because rest you guys can study on your own. Okay. So if you remember, he had said earlier that if there is a conflict between equity and common law, then equity will prevail. Okay. However, in many other cases, there is no conflict between equity and common law. Okay, so those are the cases that he identifies as a case of concurrence. So a right which is protected both under the equity law and under the common law as well as equity law. Okay, so he says a jural relation may be concurrently legal and equitable. That is, one recognized and vindicated both by law courts and by equity courts. Okay, so there is no conflict. So it will be protected by both the courts. Okay, as he says that as regards every such case, there is of course no conflict between equity and law. So we do not have this problem of deciding which prevails. Okay. So examples of that will be, if you take his first example, he says that if X has ownership, okay, and possession of a tract of land with ornamental trees thereon. So X is a possession and ownership of a particular piece of land, and there is a ornamental tree on it. Okay, Y, who's a stranger, is threatening to injure the latter. Okay, so Y, who's a stranger, is threatening to destroy the ornamental tree, as we understand so far. So here X has a right. Okay, what is that? So X has right that Y should refrain from doing so. Okay, X has a right that Y does not destroy the ornamental tree. Okay, and correlatively, what will be the Y's duty? Y's duty not to injure the trees. Okay, are concurrently legal as well as equitable. Okay, so these rights and duties are both legal as well as equitable. Okay, how? So even prior to actual damage by Y, so before the X, Y even damages the tree, belonging to X, a suit in equity for an injunction could be maintained by X. So X could approach the court of equity and seek an injunction preventing Y from damaging the tree. And after, so for example, Y still does it. Okay, so if the actual damage has happened, okay, as was done by Y, you can now approach the court of law seeking remedies. Okay, so you don't see any conflict here. Okay, so you can seek one kind of remedy from the court of equity, that is preventive in nature, and you can also seek compensation, damages, whatever, from the common law court. Okay, so they are not conflicting. It's not as if under one so it's not as if the common law court says that that person has a right to destroy the plant and the equity says that no, he doesn't. So there is no such case. Okay, it's merely saying that you have two different kind of remedies. One remedy, if the plant is destroyed, then you go to common law and then you seek damages, reparation. Whereas if you wanted one prevention of such an act on the part of Y, you approach the court of equity. So no problem here. So this is a case of concurrence of rights and correlative, concurrent duties under equity on the one hand and the common law on the other. So he gives many other examples. Kindly go through that. Let's take one more example under concurrent privileges and correlative concurrent no rights. So if you remember, just quickly, rights are correlated with duties, and then privileges are correlated with no rights. Just a second. Hello? Oh, Himanshu, what? Oh, আজি মই Wednesday কৰিম বুলি ভাবিছো, কাৰণ আজি আকৌ ইভিনিং সিহঁতৰ এই প্ৰেজেন্টেশন আছে জানা। এই এলএলএম হয় 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 চাও মই যিমানখিনি পাৰো মই কৰিম তেনেহলে ক্লাছখিনি শেষ হওক। মই তোমাক ফোন কৰি আছো ৰবা, এটা ক্লাছ লৈ আছো মই এতিয়া। হ্যাঁ হয় হয় ফোন কৰি আছো। So I hope you guys are clear so far. So rights correlate with duties, and then privilege correlate with no rights. So so he gives you an example here that in ordinary case where J has not contracted to convey a property to K. So for example, I have not contracted to convey a property to K, okay, whosoever it is, or done any act relating to K, okay. So J's privilege of not conveying such property to K, so I have a privilege of not conveying the property to K, and correlatively K has no right as to J's doing so, are concurrently legal as well as equitable. So this is quite simple, isn't it? Because the same right will be recognized both under the common law as well as equity. So J's privilege would be vindicated in a common law, in a court of law, a refusal of a judgment for damages to K, because K has no right, okay, and in a court of equity by the refusal of a decree for specific performance, because I have privilege, I have liberty. So as simple as that. So in these matters you see concurrence and not conflict, okay. Then go through other different stages of relationship, and then let's look at a case in which he finds conflict. Okay, so he, in these specific cases of conflict of equity and law, he says that ultimately equity prevails. So he says a dual relation may be exclusively equitable, that is, one recognized and vindicated exclusively by an equity code. As regards every such case, there is a conflict pro tanto between some valid and paramount equitable rule and some invalid apparent legal rule. So, as he had said earlier, if you remember, he says that the legal rule does not become invalid per se. Okay, so until certain point of time it is valid, but when it conflicts with the equitable rule, so it is invalid. So there is an apparent validity, but in actual practice it is not. So that's what he's saying. So let's take an example of a case in which you have a legal right on the one hand that conflicts with legal right under the equity. So what would that be? So Y is a tenant for life without impeachment of waste. Okay, so I am a tenant for life without impeachment for waste. Okay, impeachment of waste. Okay, and X is a remainderment in fee. So I have merely life interest. Okay, I merely have. So if I were Y, I merely have life, interest here. Okay, without impeachment or waste. Okay, so then after that, X is the remainderment in fee. So the remaining interest belongs to X in fee. Okay. So X's equitable right. Now in this specific relationship, X's equitable right that Y shall not cut ornamental tree. Okay, so X has a right that he has an equitable right. Okay, because he has a right that I do not diminish the value of the property. Okay, so that ornamental tree is the value of the property. So X's equitable right that Y, I'm assuming that I'm Y, that Y shall not cut ornamental trees. This conflicts with and repeals X's legal no right. Okay, so this conflicts with X's legal no right. So under law, X does not have a right that Y does not cut the tree. However, under equity, X has a right that Y does not cut the tree. So there is a clear case of conflict here. Or correspondingly, another case would be Y's equitable duty conflicts with and repeals Y's legal privilege of cutting the trees. So Y has the equitable duty not to cut the tree so as to diminish the value of the property. However, Y has a privilege under the law of cutting the tree. So that means he doesn't have a duty to not cut the tree. Okay, but then he has a duty under the equity to not cut the tree. So here, that is committing so-called equitable waste. Okay, but under the law, he has this, he is tenant for life without waste and impeachment. However, under the equity, he should not do something that leads to waste. Okay, so there is clear conflict between the two different rights and duties here. Okay, so what happens in such case? Okay, what will be the outcome in such case? One thing has to prevail over the other. So essentially the outcome will be that so in such case, we will assume that the equitable right that belongs in X, that Y shall not cut the ornamental tree, prevail over that of Y's privilege of either cutting or not cutting it. So that's how equity works. So if there is a clear conflict between these two different kinds of rights, okay, then equity, the rights available under the equity shall prevail. Okay. We'll take one more example, then the rest you guys can understand on your own if you merely read. So he says that if T holds Whitaker, okay, name of a piece of plot of land. So if T holds Whitaker in fee simple, okay, in trust for C, okay. So T holds the property in fee simple in trust for C. Okay. In fee simple. Okay. So C is equitable right in personam. Okay. So C has an equitable right in personam as against T, that is special or determinate right. Okay, that T shall not cut down ornamental trees, because I'm holding the property, in trust for C. So T shall not cut down the ornamental trees, because that will conflict with trees. Okay, because that conflicts with C's legal no right. Okay, and correlatively T's equitable duty not to cut down the ornamental tree. So T's equitable duty, I merely have it equitable duty not to cut down the ornamental trees, that conflicts with T's privilege of doing so. So in all these matters you clearly see that there is a conflict. Okay, under the law, I can cut down the tree, but equity says that I have the privilege. So under the law I have the privilege of cutting the tree. Okay, but equity says that I cannot. Okay, so there is a clear conflict here between equity and the law, and in such case Hohfeld says that equity shall prevail over law. So rest of the legal relations you guys can study on your own. Okay. So he says that in the last portion, that he says that the supremacy of equity over law. So in case of conflict, okay, as distinguished from concurrence, okay, we discussed both. So in case of conflict, a jural relation is finally determined by the equitable rule rather than by the legal. So ultimately, equitable rule according to Hohfeld prevails over that of legal rule. Okay, he says, since in any sovereign state there must be in the last analysis B but a single system of genuine law, since the various principles and rules of that system must be consistent with one another, and since accordingly all genuine jural relations must be consistent with one another, two conflicting rules, the one legal and the other equitable, cannot be valid at the same moment of time. Okay, one must be valid and determinative to the exclusion of the other. So what he's saying that in a legal system, okay, you might have an ultimate outcome, okay, final outcome, okay, and if you have conflicting provisions of law, so you have one set of set of laws under the law and another under the equity. If there is a conflict, then one has to prevail over the other, and the one that prevails over the other finally determines the outcome of matter. Okay, so if in such case, so equity shall prevail over the law, as he has repeatedly said. Okay, then he says that as a mere practical matter, the equitable rule would ordinarily prove triumphant because of the superior coercive procedure and remedies of the Court of Chancery. So nothing to explain there, because the procedures and power that the Court of Equity has are superior, so that will prevail. Okay. Then he says that the theoretical finality and supremacy of the rules recognized and sanctioned by the Court of Chancery may be regarded as established over the years, ever since the year 1616, the time when notable controversy between Lord Chief Justice Coke and Lord Ellesmere in relation to power and privileges of Chancellor to issue injunction against the enforcement of common law judgments. So he mentioned this Earl of Oxford case. So he's saying that this thing has been laid down essentially in that case, and ultimately in section 25 of the Act of Judicature 1873. And fourthly, he says that while the conflict as to ultimate jural relations may be regarded as having been settled since 1616, the great indirectness and complexity of the dual procedure involved in vindicating such jural relations continued until in modern times. The law courts and equity courts were amalgamated into a single legal system. Even in jurisdiction where such amalgamation has taken place, traces of the old dual system are to be found, and to some extent in the rules pleading and trial, and in modes of thought and language involved in working of the various jural problems. So he is correct, I mean to say, to a great extent, in the sense that, see, in our legal system, we do not adhere to this strict distinction as you may come across in England. So what happens in our case? So in our case, we do not have separate equity law or other laws. Okay, we have the same set of laws, but the remedies which had their historical origin in the common law court have a kind of higher sanctity over that of common law court. Okay, over the remedies that you get under the common law. So, for example, equity of redemption you have here. Okay, specific performance, all those things are here. Yeah. So injunction is a remedy provided. So all those things are there, and they have a kind of higher power over that of the other remedies. So that's essentially what Hohfeld has said, that if there is a conflict between equity and common law, then equity, being a kind of higher law, prevails over that of common law. So that's it. That's the relation between common law and equity. In the next class, we will take up nature of equitable rights. Okay, and then we will proceed to the different maxims. So thank you for bearing with me. If you guys have any confusions, clarifications that you need, you feel free to write to me, and kindly go through the article that I have shared. That is very essential. Thank you. Good day.